Did you know that if your cruise gets canceled, you're not left high and dry? Don't let it take the wind out of your sails. You have some options for recourse with the federal government. Let me show you the ropes. Hi, welcome to By Land and by Sea, an attorney breaking down the week in supply chain. I'm Lauren Beagen, founder of Squall Strategies, a maritime legal consulting company, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of cruises, let's go through my top 3 stories of the week. Number 1, the FMC extended their comment filing period on their ANPRM. What does that mean? We've discussed the Federal Maritime Commission's open rulemaking, the advance notice of proposed rulemaking, which is reviewing detention and demurrage billing practices. It was previously due on a 30-day comment period, but at the request of a big list of trade associations, it has been extended another 30 days. The comment filing period is now April 16th, so get those comments in. If you want more information on the rulemaking, what it is, how to file, check out my video, linked in the notes. Story number 2. The American shipper had an interesting article out today. Southwest Airlines cargo worker fights arbitration at Supreme Court. This is an interesting case. The question at hand is really whether airline cargo handlers are transportation workers who are not required to arbitrate employment-related disputes. So now I'm not an employment lawyer. I'm speculating here based on the simplest version of the reported facts. But this seems akin to maritime workers, no? This article explains, quote, the Federal Arbitration Act generally requires enforcement of private agreements, but exempts seamen, railroad employees, or other workers engaged in foreign or interstate commerce from arbitration to limit labor strife that prevents goods movements critical to the economy. In 2001, the Supreme Court held that the exemption only applies to transportation workers. So it looks like the facts are that the plaintiff, the one who actually brought the case, is a manager of the cargo line handlers. Okay, so maybe one step removed. But then it says that the managers are often required to fill in for the cargo line handlers. Okay, so maybe seems like sometimes they're on the line handling the actual cargo. Maybe a good hook to have them qualify as cargo workers? Let's break it down. It seems like the airline cargo worker is parallel to a maritime port worker loading cargo. I mean, they're moving cargo into a plane, and the longshoreman is moving cargo onto a boat. So even though they don't drive the boat, they're loading the cargo. Same thing here, right? Even though they don't drive the plane, they're loading the cargo. Looks like the U.S. Court of Appeals for the Seventh Circuit reversed the lower court's ruling. So the appellate court reversed the first court, which it seems may have found the cargo worker as not a transportation worker, the lower court. And the appellate court said that they think these workers actually are transportation workers. Well, that's nice. There's some discussion of foreign or interstate commerce and potentially having even Uber drivers count as transportation workers under the muddiness of the lines surrounding who is and isn't a transportation worker. It looks like the court will have to make some sort of a test to assess how far in the transportation world the exemption to arbitration clause extends. So a rule that decides who is a transportation worker and what does that mean for trying cases. Like I said, this case is hinging on an arbitration clause. Are you exempt from arbitration and can file a claim, or do you have to go through arbitration with your claims? This will be interesting to follow. As you can see, it gets a little overly legal in its discussion, but really what this is all hinging on here is where's the line between transportation worker and an accessory to the transportation worker, like a supporting role that's not an actual transportation worker themselves. Do you have any thoughts on this? Put them in the chat. Like I said, I'm not an employment attorney necessarily, but this is interesting as it will likely have an impact on transportation workers. If the test is broad enough here, the test for determining a transportation worker may extend into other areas of transportation law. And remember, this is going to the Supreme Court. Let's watch this. My number 3 story of the week. The 45th Annual Conference on Oceans Law and Policy, UNCLOS at 40, kicked off this week. This week, the Center for Oceans Law and Policy, now housed at the Naval War College, hosted the 45th Annual Conference on Oceans Law and Policy. The United Nations Convention for the Law of the Sea, UNCLOS, is the body of law that governs the international legal framework for all marine and maritime activities. It's a creation of the United Nations, as the name suggests, United Nations Convention on the Law of the Sea. So UNCLOS itself was established in 1982 after 3 rounds of discussion conferences, and the body of law covers a wide range of topics. I mean, this includes rights and responsibilities of coastal states, coastal countries, to the maritime zones off their coast. You may be familiar with these as they are the territorial sea, 12 nautical miles, the contiguous zone, 24 nautical miles, the exclusive economic zone, 200 nautical miles, and the high seas. UNCLOS text also covers the subsoil and the continental shelf. So think drilling and mining activities in the outer reach of these maritime zones. And it also covers marine conservation. It covers piracy on the high seas, hot pursuit of vessels into adjoining maritime zones, fisheries management issues, particularly by and between coastal states, and even submarine cable topics. This week's conference was the 45th iteration, and it was hosted virtually, albeit technically hosted in Kuala Lumpur. Be on the lookout for next year's conference. If you have any interest at all in UNCLOS, this is the preeminent conference on law of the sea issues. Take it from me here. Not only do I teach law of the sea for law students, but I also worked on the Extended Continental Shelf project. Remember the planting of the flag in the Arctic some 20 years ago? This is a big deal conference, and you should definitely join in next year. So those are my 3 topics of the week, but I have a bonus item. CISA, the Cybersecurity and Infrastructure Security Agency, has been revamping their Shields Up page. This is a page that discusses what you, yes you, can do to beef up your cybersecurity. They use regular language for the most part, so take a look and make sure you're protected. That means your passwords are changed with regularity. You have a 2-part authentication, so a text message code verification for signing in. Your antivirus systems have been updated, and any old work computers that aren't or can't be updated should be taken off the network. Now, this is actually a big vulnerability spot, and some of the major cybersecurity incidences that we've heard of recently may or may not have been partly due to some old computers on the system. With the increased tensions around the world, there's cause for concern of cyber warfare. And maybe it's already begun, but it's always a good practice to be prudent here. So CISA's Shields Up page is linked below. So let's get into the meat and potatoes of the day. I don't have to tell you this. You already know. Cruises took a huge hit during COVID. Unfortunately for the industry, they became one of the biggest news stories at the beginning of the pandemic, and really were never fully allowed to recover throughout the height of the pandemic. Now, I say allowed to recover. We'll discuss that in a minute. Generally speaking, cruises are regulated by the Department of Homeland Security, with the Coast Guard being a prominent agency in this regard, and the U.S. Coast Guard regulating cruises mostly for safety purposes, as they do with really any vessels in the U.S. trade regulated. Also under Department of Homeland Security is U.S. Customs and Border Protection. They regulate the movement of people and goods coming to and across our borders. But did you know that the Federal Maritime Commission also has an interest in regulating cruises? It's true. So what is the FMC's role with cruises? Although no single federal agency really has exclusive jurisdiction, we talked about Department of Homeland Security, the FMC has a mandate generally to ensure a fair and efficient transportation system in ocean commerce for goods and passengers under the Shipping Act. So that's the economic side of things. And the FMC is actually specifically involved with the cruise industry by regulating and requiring cruise lines maintain adequate financial responsibility. essentially a bond or other financial surety is available, is a requirement of the FMC. This is, in part, to refund passenger deposits in the event of non-performance or for death or injury on a voyage. The FMC regulates passenger vessels that embark from a U.S. port and have at least 50 berth accommodations. So we're not talking only huge cruise ships. Any passenger vessel that has 50 berth accommodations, so 50 rooms on board. So let's break this down. The FMC has two certificates that it issues to passenger vessel operators, PVOs, with 50 or more berths that embark from U.S. ports. These two certificates are a certificate of performance and a certificate of casualty. So these two certs cover essentially what they say. The cert of performance evidences that the PVO, the passenger vessel, has on file with the FMC acceptable coverage to satisfy any liability incurred for non-performance of transportation. So we're talking bankruptcy, or if the trip you booked doesn't run. Currently, this amount is actually capped at $32 million. This coverage is used to reimburse the passengers. That's you. When the cruise ship fails to perform the cruise as agreed and has taken no other action to refund the passengers, that's when this starts to come into play. The certificate of casualty is just what it suggests. In the event of a death or injury abroad, this certificate evidences that the passenger vessel has acceptable coverage to satisfy that liability. Now, this coverage amount is dependent on the actual number of passenger accommodations aboard the vessel. So what does this all mean? This means that in theory, even if a cruise is bankrupt or about to be bankrupt, there's still a pile of cash to cover these occurrences, death or non-performance, no trips. So during the pandemic, one of the FMC commissioners, Lou Sola, he's from Florida, makes sense he'd take an interest in this, right? Looked into the economic impact of COVID on the cruise industry. So tell me more about Commissioner Sola's work. Well, okay. Commissioner Sola sought to review 3 different missions. He wanted to engage the cruise industry stakeholders to identify commercial solutions to COVID-19 related issues interfering with the operations of the industry. He wanted to interact with all or any maritime related COVID-19 task forces in order to gather information and data related to the impacts of COVID-19 on the cruise industry. And he wanted to establish at least one team of leaders from the cruise industry, as well as other stakeholders, to develop commercial solutions to the challenges created by the COVID-19 pandemic. So this endeavor was the FMC's fact-finding number 30. The final report was released on January 14th, 2022, just a few months ago, and had some really interesting findings. There were a few notable findings. First, cruise line refund policies. Commissioner Sola's report made proposed changes for passenger refund processes. We'll get into that in a minute. It also found modifications in the $32 million bond requirement for smaller passenger vessels. So if you're a smaller passenger vessel, you may not need the $32 million bond coverage. It was suggested that the FMC should review this request. Financial impacts of cruising in the U.S. was also reviewed. So in 2019, it was found that the cruise industry was responsible for over 25 billion, that's billion with a B, in direct spending by the cruise lines, cruise passengers, and crew, and accounted for an estimated 435,000 jobs throughout the country. Now, due to cruise operation disruptions, $39 billion, another B, in total economic losses occurred between March 2020 and March 2021. That's just a one-year period, $39 billion. You know, in one of the interim findings, it was actually even said that a gas station 150 miles away from the cruise port was even affected by the cruise industry shutdown. Now, this is a big industry and a major section of the economy, as this report found out. We may have already known that the cruise industry was a major economic factor in the U.S. economy, but these reports, and certainly these timely reports, are really important to provide that data to support the industry, as many other areas of the economy were also hard hit. But even as the rest of the economy began opening up in stages, the cruise industry was sidelined and not really allowed to open, either due to direct restrictions on their operations or incredibly restrictive CDC guidelines, creating insurmountable hurdles to operations. But let's get back to what all this means for you. Let's talk more about the passenger refund rules, right? The FMC published a final rule on March 17th, amending their regulations governing non-performance by passenger vessel operators. So, what happens if a cruise ship doesn't sail its scheduled itinerary, either via cancellation or delayed voyages? The rule establishes new requirements for when cruise passengers should be provided refunds for canceled or delayed voyages. So, what are those changes? The definition of non performance is now refined to be canceling a voyage or delaying a voyage by 3 or more calendar days if a passenger elects to not embark on a delayed or substituted voyage offered by a passenger vessel. So, if your ship is either canceled or delayed by more than 3 days, and you don't like the substituted cruise or options, and you can't hop on the boat after it's been delayed for 3 days, you have options here with the FMC. It's also changed its regulations to allow passengers of delayed or canceled voyages to make direct claims against financial responsibility instruments. These are the bonds that are managed by the PVO, the passenger vessel, after the passenger's unsuccessful attempt to receive a refund directly from the passenger vessel. So you do have to try to receive that refund from the passenger vessel itself, the cruise line itself first. But if that doesn't work, this rule allows you to now go directly to the financial responsibility instruments. So finally, the rule also allows all fees, including ancillary fees, paid by a passenger to a passenger vessel to be eligible for a refund. No games. Like I said, this is a final rule. So this comes after a notice of proposed rulemaking released in August 2021. So at that time, 6 comments were received and their comments were taken into consideration and the final rule was amended. Now we've talked about the different rulemaking sections. This detention and demurrage rule that we've been talking about is an advance notice of proposed rulemaking. We've talked about this before. This is where questions are asked to the industry for input on the creation of the first text of the rule. The next phase is usually the notice of proposed rulemaking. That's what we had here in August. This is a draft text of the rules released and open for comments, but an actual draft text is created. Then, the stage we're at now, the final rule, this is the final text. And if nobody comments on it, then it will become the final rule. The final rule stage still has an opportunity for objection, though. If you comment on the rule and your comment is substantive, the agency will likely have to respond. But this is really the last chance. It's way better to comment at the earlier stages, which is why I keep repeating that the ANPRM, the Advanced Notice Proposed Rulemaking stage that we're in for the detention and demurrage rule, it's the perfect time to be commenting. And that's why they've extended that comment period. The notice of proposed rulemaking that was released in August would have also been a perfect time to comment. But like I said, you're not without opportunity here. You can still comment on this final rule. It'll close in April. So why are we talking about all of this? Why are cruises important right now? And why are refunds on cruises important right now? You may have heard Crystal Cruises went bankrupt this year. U.S. Marshals seized 2 of Crystal Cruises' luxury ships, the Crystal Serenity and the Crystal Symphony, with people aboard. This was done in the Bahamas due to an over $4.6 million unpaid fuel bill. So by February 11th, Crystal Cruises had closed down its U.S. operations and closed its offices and laid off all remaining employees. Gone, vanished. So this is where the FMC came in. The FMC has a general landing page for cruise passenger assistance, compensation for cruise line cancellation or death or injury during a voyage. But the FMC also created a page for passengers affected by Crystal Cruises. It was actually updated this morning even, March 18th. On the Crystal Cruises announcement page, the FMC lists the website where refund requests can be made, crystalcruiseclaims.com, and the deadline of June 11th for making these claims. The FMC has an office that is very helpful to consumers. It's the Bureau of Consumer Affairs and Dispute Resolution Services, CATERS. This is a great first stop for cruise questions. Initial inquiries, really, it's just an easy access point to the FMC for the U.S. consumer. This office is a no-fee for services office. You don't have to pay for their services. And they offer ombudsman assistance, mediation, facilitation, and arbitration to resolve challenges and disputes. And these could involve issues such as cargo shipments, household goods shipments, cruises, and really any other general CATERS resources. a really helpful office that is definitely under-realized and underutilized resource. I'll link the office in the show notes as well. So that's it. If you're having a problem with cruises not sailing or refunding your money or whatever, the FMC is a great resource to help you navigate these murky waters. See what I did there? I know in my videos I tend to have a positive view of the FMC. Maybe it's because I worked there for a while and enjoyed my time helping the industry through that work, or maybe it's because it really is just a nice agency that truly is trying to help the industry be more fair and more efficient. I've said it before, they're not fast, but they're purposeful. And from my experience with the politicals and the staff, they truly care about what they're doing and they want to help. So do you have any questions about any of this? Contact me at Squall Strategies, my company. Again, the guidance here is general and for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. If you like these videos, let me know. Comment, like, and share. If you missed any previous videos, these videos live on my YouTube page, By Land and by Sea. So until next week, this is Lauren Beagen, and you've just listened to By Land and by Sea. See you next time.